Everyone, I will call the State of Rhode Island Coastal Resources Management Council to order. Today is Tuesday, June 10, 2025. This would be our semi-monthly meeting. I would ask that the record reflect the council members that are present, as well as CRMC staff and our attorneys. First matter on our agenda will be approval of the minutes of the previous meeting, that being May 13, 2025. I know Lisa has disseminated them. I would entertain a motion to accept them unless there are any proposed changes, please.
Motion to accept the minutes.
A motion has been made. Is there a second?
Second.
Motion seconded by Dr. Ruda. It was made by Ms. Reynolds. Any discussion? All in favor, say aye. Aye. Anyone opposed? Let the record reflect the minutes have been accepted unanimously. Director Willis, any subcommittee reports?
Yes, Mr. Chair. The Rights of Way Subcommittee met earlier today on matters of Spring Ave extension, westerly potential right of way. A number of matters were taken up, one of which was to find a location in the town of Westerly to begin the evidentiary hearings for the subcommittee to pursue whether or not Spring Ave should be designated as a right of way, in addition to a couple of other matters that were looked at by the subcommittee. So staff will be looking to find a venue in Westerly and make sure that all the parties are able to attend at a date in September of 2025.
Any questions of Director Willis from the council on that report? No. Staff report?
Yes, Mr. Chair, just a couple of items. I had mentioned at past council meetings the potential issue of federal funding under the current administration being held back, the NOAA funding being held back, of which this agency relies significantly on. It funds 10 staff. It's sometimes as much as half of our budget, our annual budget needs. And we had basically been told, with the administration holding back current federal fiscal year funds for the 34 coastal programs in the country, as well as many other federal programs. We didn't know what the status of that would be, because we normally have at this time a known amount of money that we would apply for, have approval for, and be able to use come July 1 of the beginning of a state's fiscal year. We just got word last week that NOAA will allow the 34 coastal programs to submit their applications for federal funding using last year's federal fiscal year, last year's numbers, for us to apply for, in hopes that the administration will release it. So it's not finalized, but it's at least we're allowed to move forward with the application process, because it appears that the administration will be releasing those funds. Good news, but we won't see that money on July 1. We'll be lucky to see it in the fall, or maybe even by the end of the calendar year. So Laura and I are working with our administration on basically a bridge plan, what to do in between July 1 and when the state actually sees those funds. I am certain that there are several other agencies of this state and the other 49 states that are in the same boat as we are. But we are working closely with our federal counterparts, as well as the state's OMB folks, to address this issue and make sure that we can continue moving forward as expected. Lastly, we continue to meet with South Coast Wind. We actually met today, and part of our bi-weekly meetings with them, we meet every other week. We work on issues that we're moving forward on relative to their cable that they proposed, their export cable from their offshore wind farm that they proposed to come up the Sakonnet River. We have worked on any number of issues associated with that. The latest being is that we had the Fishermen's Advisory Board meet with the developer to discuss what the issues of the impacts from the cable would be to the fisheries in the Sakonnet and then up into the Mount Hope Bay, where the cable will actually make its way into Massachusetts waters. South Coast has yet to provide the exposure data on those fishery impacts. The exposure data will help us understand what mitigatory matters we might want to look at doing for that particular activity, as well as if we can't entirely mitigate for the environmental impacts and the fishery impacts, what compensatory matters can be taken. We're waiting for that information from South Coast. However, we continue to meet with them and hope to have the matter in front of you all by the end of the summer. But again, that will be contingent on getting data from South Coast and discussing what the impacts to the fisheries are through their exposure data. That's it, Mr. Chair.
Any questions of Director Willis on that report? Hearing none. Brings us to our first matter and only matter this evening. Is 23-0185 Quidnessett Country Club. It's an order to restore before the council for review and action as it relates to an unauthorized riprap, revetment, unauthorized cutting of vegetation on a coastal feature, and an unauthorized filling of tidal waters. These unauthorized activities took place along CRMC designated Type 1 waters and are prohibited by the Rhode Island Coastal Resources Management Program, parentheses RICRMP, close parentheses. It is down for A, discussion and action on a motion to assign to a hearing officer. B, discussion and action on the order to restore. Attorney Savenka is here on behalf of Quidnessett.
Thank you. Good evening, Chairman, members of the council.
Hold on 1 second. Should we pass the motion? Here for us, that should.
No, I think the motion to assign is appropriate first.
Okay,
I would like it taken up first.
that's what we would do.
We had filed a motion to assign this enforcement matter to an administrative hearing officer. You have the motion that's in your packet that's part of the enforcement report. And there's a few reasons why we believe that it's both mandatory and appropriate. First, as you know, there were 3 notices of fine that were issued to Quidnessett Country Club in 2023. And each of those notices provided a right of appeal to a hearing officer, which we timely took by letter of October 10th, 2023. That letter is in your packet. This is consistent with Rhode Island General Laws 4623-7.1 subpart 2, which requires that a hearing officer be designated when an appeal is taken, as we did. That request for an administrative hearing officer was reiterated or renewed twice, once in May 2024 and another in March 2025. And those 2 letters are also part of your enforcement report packet. Second, there is certainly a material contested issue that relates to this restoration, and that's the line to which the restoration can be built to. Some refer to it as the toe of the slope, others refer to it as the toe of the berm. And that line is critical for the club because if the line that's being advanced by CRMC staff is adopted, that means that the country club will have to cut into its golf course, which has been long-standing since the 1960s. The line that we are advancing, you'll hear about a little bit later. It's called the magenta line. It's further seaward. It's consistent with what was constructed in 2013 as approved by the CRMC. And you can see in your enforcement report packet that there's extensive correspondence between CRMC staff and the club as to the location of this line. Again, that is material and affects our property rights. Another matter that we haven't been able to reach yet because we haven't been afforded our appeal is that there is one notice that is for the ripping out of vegetation on our shoreline, which if you look at any of the photographs from December of 2022, all of that was taken out by Mother Nature. The shoreline protection that was approved and installed in 2013 completely failed. By, within 10 years and by the end of 2022, with the burritos being ripped out and with the vegetation being ripped out as well. So we do contest that violation. I also wanted to point out, which is in our motion, a recent decision from the Land Use Court, Judge Lanphier, the Dumplings Association versus CRMC. That's PC 2021-00296, decided January 27, 2025. And in that case, Judge Lanphier had ruled that the agency's failure to follow its rules on assignment, and that case, it was a contested application, and the rules or the statute required that contested matter be referred to a subcommittee, which had not been done. And he, in evaluating that, determined that that resulted in a failed procedure, and the matter up on appeal, then he vacated the decision that was based on that failed procedure, and he remanded it back to the council for following of that procedure. Again, that was a contested application. We're talking about a contested enforcement proceeding. But the holding sticks because it's following of the statutory directive to refer matter to a particular body or hearing officer subcommittee. There is an exception for not referring something to the hearing officer if the hearing officer is not available, but there has to be then a finding by the council that the hearing officer is not available. And then in that case, the circumstance would be you'd have to refer it to a subcommittee. And that hasn't been done in this case. So if, the two statutory provisions, both Rhode Island General Laws 4623-7.1 subpart 2 and Rhode Island General Laws 462320, where there's a contested enforcement proceeding, a matter shall be heard by the administrative hearing officer, and the Dumplings Association versus CRMC case seem compelling to me, and in our position dictate that this go before the hearing officer. That does not mean that this would not end up back before the council. As you know, the hearing officer would render findings of fact and conclusions of law, and that would be a recommendation back to this body, who would then decide if they would adopt, revoke, or modify it. So in conclusion, our position is that the council does not, at least now, have jurisdiction to consider this contested enforcement proceeding. And we have a pending right of appeal to the hearing officer, and that we ask that the council vote to assign it as required by statutory law.
Okay. Mr. Willis?
Mr. Chair, we don't believe this is a contested matter at all. We actually think it's a pretty straightforward matter, because the case in front of the council tonight, which is the dumping of unauthorized riprap revetment on a coastal feature, unauthorized cutting of vegetation on a coastal feature, and unauthorized filling of tidal waters, has never been contested by the country club. In fact, and interestingly, the country club admits to such actions in its motion to assign, specifically at the first full paragraph on page 2 of the motion, where it states in part, to protect against further damage to the land and the threatened loss of the 14th hole, QCC began implementing replacement shoreline protections in January of 2023. And additionally, if you'll recall, during the country club's separate arguments to revise the council's water type regulations, which would have allowed the unauthorized revetment to remain in place, this same admission was made several times as a straightforward fact of the matter. Because those admissions exist, they're part of the record, and they're part of the country club's actions to undertake prohibited activities that are regulated by the CRMC. The case simply is not contested.
Any questions of Director Willis?
Before we continue on, reference was made to section 46-23-7.1 of the general laws. And if you take a look at that statute, not only don't you need a request for the appeal, you also have to state with specificity that the reasons for your appeal, which wasn't done here. There was a request, but I think that's a further acknowledgement that this isn't a contested matter. And in fact, I don't think it's appropriate on a legal basis to send this matter to either a hearing officer or a subcommittee.
May I address what you just
One
noted?
sec.
Okay.
Any questions from the council to Director Willis or Attorney DeSisto?
I do have some questions and concerns about the motion to refer this matter to the hearing officer. And I focus on.
Can I stop you there 1 sec?
What?
Should we let Jennifer continue and finish her argument, or for what you're gonna say pertains to what's been said already?
Well, it's been said, it's been referred to already. I think maybe council should respond.
Okay,
To
yeah, let's do that.
Chairman Willis and our council first.
Right, so I wanted to address the comment from Attorney DeSisto that there was not specificity in the request for appeal. And this was something that was taken up in the dumplings matter and was used to, resist that, they were not entitled to this procedure because they hadn't raised particular arguments. And his response was, this is jurisdictional. If it's alleged, the proof can be made at the hearing to be held that's being requested. And you don't have to produce proof of what it is that it's contested. It suffices if you state that that there are contested matters. And as I noted earlier, we do dispute the ripping out of the vegetation along the shoreline. That's one of the 3 stated violations. That was done by the storm system that happened in December. There were a couple of storms in December of 2022. And so that's one of the violations. And I do want to emphasize the importance of this restoration line that we have a difference with staff on. It's a material issue for this restoration and makes the difference between being able to construct something on a slope out to the water and not affect the golf course, or having to cut into the golf course. And this, again, this is a golf course that has been in place since before the program came into existence in 1983, since it opened in the 1960s and was well in place. We've made these arguments as part of our water type change application, but I do want to emphasize the pre-existing nature of this development. So we have 2 contested issues that we believe merit being referred to the hearing officer. That's one, and that's under Rhode Island General Laws 46-23-20, which requires all contested enforcement proceedings to go before the hearing officer. But we also have the appeal that we took under 46-23-7.1 subpart 2, which is as of right. And we have not been afforded that right, even though we have been requesting it since 2023. Thank you.
Thank you. Mr. Rizzi.
Going back to what I was saying before, I look at 46-23-20 and kind of plain language of the statutes is all contested cases and all contested enforcement proceedings, et cetera, are referred to the administrative hearing officer, which we now have. This is an enforcement proceeding. So I'm not sure why the staff and council's position is that the applicant or respondent can't request a hearing before the administrative hearing officer. It seems to fit within the parameters, at least of the statute. And it also requires all contested administrative fines be heard by the administrative officer. And if we were to fine Quidnessett, then I think they would again be within their rights to request a hearing before the administrative hearing officer. So that's kind of what I'm struggling in questioning. It shouldn't be sent over to our hearing officer.
I think to just restate what Director Willis said, the issue for tonight is the wall itself. And there is no contest that that wall was constructed without permission and in fact violates the CRMP. So the issues that are talking about is what the resolution would be. It's not what the violation is for, which is the fact that the wall is there. That hasn't been contested. And the second part is, you know, for that particular issue, there's really been no stated reasons for that because it can't be. The real issue is I think what we're hearing tonight, the real difference is how the remedy should take place. I think that's why it's here now and why I've given the advice that I've given on this and why you've heard from the director what staff's opinion is. The issue is the wall.
Yeah, well, maybe my struggle may be with the way that it's come to the CRMC. I mean, is this an application to construct or reconstruct or leave in place or modify the existing structure at Quidnessett Country Club, or is it simply an enforcement hearing on the removal of the wall, the riprap, or whatever you want to call it?
It's the
Because
last.
it seems
The restoration.
well, then that's going to determine what we're going to hear tonight. Because if it's not replacement or modification or revision of the existing and simply whether the current wall violates the rules and regulations in the existing sense of CRMC, that's a different hearing from the one that started to be presented by Quidnessett Country Club. Are we going to make a determination of what the remedy is, what wall is going to be built or reconstructed or modified or moved, or simply that the existing wall that's there now does not comport with CRMC rules, regulations, and prior assents to the owner of the property.
It's the latter, not the former.
Do they know that?
Oh, yeah.
Then we shouldn't be hearing anything about magenta lines or new walls or any different construction, correct?
Well,
Not to put you on the spot.
but you're not putting me on the spot. This is an enforcement hearing and for a restoration. That's the issue.
All right. Okay,
And very shortly, depending on how the council votes on this, you may be hearing from staff as to how this wall doesn't comply with the CRMP.
okay. All right, good night, peace.
Any questions of Attorney DeSisto in light of the discussion from the council? There's a motion. Is there a motion from the council as it relates to the request and motion to assign it to a hearing officer? Mr. Russolino,
I agree with Director Willis's assertions and motion to deny the request to assign this matter to a hearing officer.
motion has been made by Mr. Russolino to deny the request to assign the matter to a hearing officer. Is there a second?
Second.
Seconded by Mr. Gagnon. Is there any discussion?
Yeah, I will just put on the record that, based on the prior discussion with council, with our council, I will support the motion on the floor. But I think it certainly will impact on the evidence that's presented tonight.
Okay, I will now poll the council. Ms. Izzi,
Aye.
Mr. Russolino,
Aye.
Dr. Ruder,
Aye.
Mr. Gagnon.
Aye.
Ms. Reynolds.
Aye.
I too, Raymond Coyer, vote aye. Next matter on the agenda is discussion and action on the order to restore. Because, Mr. Harrington, you have this.
Thank you, Mr. Chair. I'm gonna start off by giving a brief summary of this violation. And we're here seeking an order to restore. In response to a complaint on August 18th, 2023, CRMC staff inspected Quidnessett Country Club in North Kingstown, found that three violations had taken place in CRMC jurisdiction. The first was the construction of an unauthorized riprap or vegetation. The second was the unauthorized cutting of vegetation on a coastal feature. And the third was the unauthorized filling of tidal waters. These unauthorized activities took place along a portion of Narragansett Bay that is designated by the CRMC as Type 1 waters. The unauthorized activities found by staff are prohibited in Type 1 waters by the Rhode Island Coastal Resources Management Program. On August 28th, 2023, cease and desist order 23-0185 and three $10,000 notices of administrative fines were issued to Quidnessett Country Club. Quidnessett Country Club appealed the three administrative fines on October 10th, 2023. Over the course of the next 7 months, CRMC staff engaged in settlement discussions with Quidnessett Country Club. These talks were unsuccessful. On May 22nd, 2024, a letter was sent to Quidnessett Country Club requiring that a complete acceptable restoration plan be submitted to the agency by June 21st, 2024. This letter explained in detail that a proposed restoration plan was required to include the removal of all unauthorized riprap and fill, the stabilization of the coastal feature, and native shrub and tree plantings. To date, 5 proposed restoration plans have been submitted and determined to be unacceptable. Next, I'm going to provide an overview of the programmatic violations. Section numbers are those contained in 650-RICR-20-00-1, also referred to as the Red Book. The first violations listed in the staff report are general programmatic violations regarding the fact that no council assent was issued before work occurred on a coastal feature. These sections are section 1.1.3A1 and 1.14A1. Now I'm going to talk about the work that was undertaken that is explicitly prohibited in the Red Book. The first category is unauthorized earthwork, filling, removing, and grading on a coastal feature. I will be reading the exact text detailing the prohibitions for the record. Section 1.3.1J3A, filling in type 1 and type 2 waters is prohibited. Section 1.3.1B2A, filling, removing, or grading is prohibited on beaches, dunes, undeveloped barrier beaches, coastal wetlands, cliffs and banks, and rocky shores adjacent to type 1 and 2 waters, unless the primary purpose of the alteration is to preserve or enhance the feature as a conservation area or natural buffer against storms. Section 1.3.1E2B. I would like to point out that there is a mistake in the wording of this section in the staff report. It repeats the language in the prior section. It should read, the regulation should read, filling, removing, or grading on a coastal wetland is prohibited adjacent to type 1 and 2 waters and in coastal wetlands designated for preservation adjacent to type 3, 4, 5, and 6 waters unless a consequence of an approved mosquito control ditching project. See section 1.3.1L of this part. The second category of prohibitions is in regards to unauthorized construction of a riprap revetment on a coastal feature in type 1 waters. 1.1.5A. This is in the activity matrix for type 1 waters. Filling, removing, and grading and structural shoreline protection are both prohibited on headlands, bluffs, and cliffs and rocky shores in the matrix. Section 1.2.1B2C. In type 1 waters, activities and alterations, including dredging, dredged materials disposal, and grading and excavation on abutting shoreline features are all prohibited unless the primary purpose of the alteration or activity is to preserve or enhance the area as a natural habitat for native plants and wildlife or a beach renourishment replenishment project. Structural shoreline protection facilities shall not be permitted to preserve or enhance these areas as a natural habitat or to protect the shoreline feature. Section 1.3.1G3A, the council shall prohibit new hybrid and structural shoreline protection on barriers classified by the CRMC as undeveloped, moderately developed, and developed, as well as shorelines abutting type 1 waters, unless the shoreline is determined by the CRMC to be a man-made shoreline as defined within section 1.1.2 of this part, or is permissible under section 3.4.12 of this subchapter. Section 1.3.1G3C, filling on a coastal feature or tidal waters beyond that which is consistent with section 1.3.1G5A of this part is prohibited. Section 1.3.1G3D, shoreline protection is prohibited when proposed to be used to regain property lost through historical erosion or storm events, unless the project is a marsh sill designed for a wave attenuation as part of a marsh creation, enhancement, or restoration project. In light of these prohibitions, staff has consistently required that an acceptable proposed restoration plan includes 1, the removal of all unauthorized riprap and fill, 2, non-structural stabilization of the coastal feature, and 3, native shrub and tree plantings shown throughout all previously vegetated areas. These 3 elements were specifically requested in 8 instances of correspondence sent to Attorney Cervenka between March 22nd, 2024 and May 9th, 2025. To date, 5 proposed restoration plans have been submitted and determined to be unacceptable due primarily to the proposed location of the quote-unquote toe of berm. The toe of berm is the seawardmost location of any proposed non-structural stabilization work. To determine the acceptable seaward extent of the toe of berm, staff relied upon the most recently authorized location as depicted on the approved plan associated with CRMC Emergency Assent 2013-3-133. However, staff would like to note that what was actually built in 2013 did not match the plans. Quidnessett has consistently proposed this as-built tow in their submitted restoration plans. Staff cannot support the use of a tow berm that was out of compliance as a standard for restoration. Thus, in a proposed restoration plan, staff cannot accept a tow of berm further seaward than the blue line labeled approximate tow of clay as shown on the plan title, previous approved plan overlay, dated revised February 3rd, 2025. Finally, staff recommends that the council order Quidnessett Country Club to restore the site within 90 days of this order by doing three things. The first is to order that all unauthorized riprap and fill be removed within 60 days. The second is to order Quidnessett Country Club to submit a complete acceptable restoration plan for stabilizing the site using non-structural means within 30 days. Staff would like to note that the plan titled Coastal Restoration Plan submitted to the agency on March 28, 2025 included many elements that were workable. The major unacceptable element of the plan was the location of the tow of berm. This plan was withdrawn from consideration 10 days later. Staff recommends that in developing a proposed restoration plan, the Quidnessett Country Club start with the March 28, 2025 plan that show the tow of berm no further seaward than the blue line labeled approximate tow of clay envelope as shown on the plan titled previous approved plan overlay dated revised February 3rd, 2025. And the third thing is to order the restoration and stabilization of the site in conformance with an approved restoration plan within 90 days. Thank you, Mr. Chair.
What was the date of the plan that you could work with? Did you say March or?
March 28, 2025.
Thank you. Any questions of Mr. Harrington from the council? No? Attorney Savenka, do you wish to address that topic?
Yeah, I have two engineering witnesses here with me tonight, and I would like them to address the 2013 approved plan and also address the plan that we last proposed to the CRMC staff.
Okay, I'm gonna ask council, are we at this point going to allow testimony in consideration of proposed plans, or are we just dealing with the order to restore?
Well, I think that's what Mr. Rizzi was asking.
Exactly.
The question is if the issue for tonight is whether or not there's a violation and there has to be a restoration.
Right.
I think the testimony that to be submitted should be based on that.
Okay. Okay. Good.
So I would just say to that, there has been a recommended order that would have us use a restoration line that is contested. That is one of our main contested issues for which I would like to present testimony. So I don't quite know how it fits on what we're doing here tonight, as you may have limited it, Attorney DeSisto. But if there is going to be an order that's presented to vote on, I would like to be able to present a witness who can respond to the line that they want us to observe because it is disputed.
Your thoughts? Because part of what Mr. Harrington said was for them to submit plans that would be acceptable through working together. So I guess my concern is it a decision we're making this evening on approving the restoration plan, or we're making a decision to have them continue to confer and consult with staff to come up with an acceptable plan? And if that's the case, then I don't see why we're making a decision relative to the line.
The main issue is the violation in the restoration. Staff has made some recommendations on that in broad strokes, but I don't think that it is appropriate for the council to enter an order with specifics as to restoration based on the staff report.
Okay,
So there will be no vote on restoration? Is that what I'm hearing?
all right, I think we can make a vote on the order to restore. But I guess I'm saying this in a question form, but are we taking the next step and saying, this is what you must do and how you must restore it?
I think the vote is, as Mr. Jersey said, on the violation. And if a violation is found, then in order to restore. And I think the specifics for the order to restore, as you heard from Mr. Harrington, would be based on a staff review of what's ever submitted in a timely fashion.
It's not answering my question. I guess my question is, are we substituting our judgment and interpretation as a council for Mr. Willis, Mr. Harrington, whoever else, Mr. Venker and her experts that may sit down and come up with a plan outside of this hearing?
Yeah, I'm not suggesting that. But to get to that point, I think what the council has to do is to find the violation in order the restoration. So it can get to that stage.
I understand that. But is the witnesses, are the witnesses that are being proposed this evening addressing that issue, or is that not something that we would consider?
I mean, we've talked about working with the staff on an acceptable restoration, but we have a dispute as to that restoration line that we will not agree to. It will have to go before a decision maker with evidence presented. And I have two witnesses who would present on that. They've already put the, I didn't see, but I think that they put one of the demonstratives up that showed the blue line that they would like to have as part of their restoration, which we disagree with and is not supported by the good evidence and research that our engineer did. So if there's going to be a specific order on a type of restoration using a particular line, I would like to present my witnesses on that. And it's contested.
This question,
Sure.
could the council just order that the restoration has to meet staff's requirements? Just leave it at that.
Yeah, I think that's what the staff is recommending. Which is, so essentially what's going on is if there is a finding of a violation in order to restore, you're delegating the solution to the restoration to staff. Does that answer your question?
Yes, that's what.
But with respect, I don't think it can be resolved between us and staff because of the line. You know, it is what is preventing our agreement. And it just gets back to, you know, everything I said in the motion to assign. This is the contested issue in this restoration, and it won't be by consensus. I think it'll have to be made by a decision maker. We were hoping that would be a hearing officer pursuant to the authority, but it's very procedurally unusual and I don't think appropriate.
To all due respect, building what you did is also procedurally inappropriate, so let's not split hairs over it. So
There's
I think that, can we vote on moving forward with with us moving forward with the order to restore first,
Well,
and then we can move forward with how to restore. Is it two separate issues or one issue?
well, Doctor, I think you're actually, that's what I was going to recommend. Your first motion should be whether or not there is a violation. That's the first thing. The second motion should be a restoration, then we can address these issues.
So I could,
So
I'm looking for a motion.
okay,
My motion would be to require Quidnessett Country Club to, one, remove all unauthorized riprap and fill within 60 days. And two, submit a complete acceptable restoration plan for stabilizing the site using non-structural means within 30 days. The restoration plan shall include the recommendation of the CRMC enforcement staff. And three, restore and stabilize the site in conformance with the approved restoration plan within 90 days.
Is that based upon a finding that there was a violation here? Thank you.
for that motion, is there a second?
second,
Motion has been made and seconded. Any discussion? I have a discussion. So I can support some of what you said. Upon a finding of a violation and your order to immediately remove the unauthorized wall, as I call it, I'd like to see that stayed, a stay of that, because then you also ask them to do some things after that. So I could be prepared to accept a removal of the wall, but you stay that for 120 days. Have them deliver to CRMC staff an acceptable restoration plan within 30 days, as you said, the 30 days. Commence and complete the restoration within 90 days from the date that the acceptable plan is filed. So it affords them an opportunity to continue to work with staff, come up with an acceptable restoration plan, not require them to immediately tomorrow start taking down the wall that's there, but maybe incorporate the removal of that with the building of what's ultimately an acceptable plan, hopefully there, and then give them 90 days to complete it from the date of the acceptable plan being filed, because we have to afford them an opportunity to get contractors and builders, and obviously we know it's the summer season there and things are happening there as well.
So modified.
So
There's been no second, so you can modify your motion.
Modified on Cheetah's.
Dr. Ruda had seconded it.
Oh, I beg your pardon.
Well, that's why I thought the discussion. Yeah, so we had the original motion from Mr. Russolino, seconded by Dr. Ruda, and then some discussion. Any other discussion?
I have a question for staff on the submitted plans, and it might not be the appropriate time to ask this question. In looking at this, there's restoration of the seawall, restoration of vegetation, but there's a new asphalt cart path that runs right along there, which is definitely new. You can see from the prior photos of this one. Is that part of your restoration?
If the work that was done included that, then yes.
All right, so I think Mr. Russolino had amended his motion to incorporate my statements. Procedurally, tell us how to,
Does Dr. Ruder accept that and second that?
I second that, yes.
okay. That's what we have before us right now. Any further discussion? I'll hold the council. Mr. Izzy,
Aye.
Mr. Russolino,
Aye.
Dr. Ruder.
Aye.
Mr. Gagnon,
I,
Ms. Reynolds,
Aye.
I too, Raymond Coyle, vote aye.
Oh, wait a second, is that it? It's it. Okay, motion is to adjourn.
Having no further business.
Can
to come.
I just get clarification on that motion? It was 30 days, that the first with the removal being stayed for 120, correct?
Correct. And deliver to CRMC staff an acceptable restoration plan within 30 days. And commence and complete the restoration within 90 days from the date the acceptable plan is filed. So those two total the 120, and that's why it stayed 120 days. I entertain a motion to adjourn.
So moved.
Motion made and seconded. All in favor, say aye.
Aye.
Anyone opposed? Motion carries. Thank you.